Hi there, I'm James Dapperchi, and this is Coffee and a Case Note. So team, today, corporate oppression and I need a massage. We are dealing with a corporation and we're dealing with two natural persons. And at the commencement of the facts today, one of those natural persons is the sole shareholder and director of the corporation. And what is said is that these two natural persons enter into an agreement whereby they will fund the purchase of a massage business. And the purchase, once purchased I should say, the owner and operator of the massage business will become the company. After the purchase, we will then have our two natural persons as directors of the company, and we will have our two natural persons as shareholders of the company. And what is the company called? It has the fantastic name of I Need a Massage Pty Limited. So look, I'm not one to give you advice on rigging. Maybe I am sometimes someone to give you advice on trademark law, but it strikes me as a good name, if a little descriptive, but we'll leave that discussion for another day. What we have is then that business owned by that company begins to tick over, but sadly, our two natural persons fall into an irretrievable breakdown in relations. And what happens is that our defendant causes our plaintiff to be removed as a director from the company, and also causes our plaintiff's shareholding to be reduced to nil. After doing this, our defendant then causes the company to sell the business, remembering that a company and a business are two different things. So our defendant causes the company to sell the business and takes the proceeds of that sale for himself. And so what our plaintiff does is commence proceedings pursuant to section 232 and 233 and also 461, but we'll leave that discussion for another time, of the Corporations Act. And the orders she is after, forgive me, orders that the company be wound up. Now, if we just have a quick moment when we think about corporate oppression, we'll dive into it a bit later as well. We sometimes say, look, the areas for relief in relation to corporate oppression, sorry, and you've got the sun right behind you there, that's better if you'll forgive my hand. The areas for relief for corporate oppression are either a share sale or a wind up. And while that's not strictly true, because section 233 allows us to do a lot of things, we often say, right, if there's corporate oppression, do we want share sale or do we want wind up? Anyway, back to the facts today. What our plaintiff says is that by removing me as director and by reducing my shareholding to zero, you acted in a manner that was commercially unfair. And what the court essentially says is, yeah, tick, that's right. Section 232, unfairness test, that is passed successfully. Well done. Whoever gave me advice about setting up a video with natural light behind it, I'm going to need a gloss on that advice. Anyway, let's press on. And having proved the Section 232 commercial unfairness, we now turn our attention to whether the court will exercise its discretion to order Section 233 relief. And the short point is, it does. The court says, right, well, because the plaintiff's shareholding was reduced to nil, the plaintiff is not a shareholder, meaning that a share sale wouldn't be of much value because she's got nothing to sell, our plaintiff. And working through the options, the court essentially finds that there's no other path to relief for the plaintiff but the order of a wind-up of the company. And that is what happens. So I hope that adventure through a sort of crunchy, difficult relationship between directors and shareholders and the operation of the law of corporate oppression was of value to you. And I look forward to joining you for another sunny morning, coffee and a case note soon. Cheers. So I consider myself very open to advice. I've got advice on microphones and on tripods and phones and how to film these things. And one of the bits of advice was face natural light. And you have over your shoulder there the morning sun, and it's making life interesting. So that means I'm open to further advice about dealing with morning sun and that sort of thing. But hopefully I can bring you a bit of value this week with a discussion about corporate oppression, Section 232 and Section 233 of the Corporations Act, and here a really difficult situation where a defendant reduced a plaintiff's shareholding to zero and removed the plaintiff as director, and the plaintiff succeeded in getting the company wound up as a result. Anyway, I'll link it for you, and I hope you have a nice sunny day, but that you manage the sun better than I have. Cheers.